Good afternoon. This is the second of the three introductory videos that Sharman and Sharman, my law firm, will be sending you. This particular video is meant to help you get prepared for your consultation. Now, I'd like to go over just briefly what it is that identity theft does to a consumer and what the law is in terms of providing a consumer with some relief and what our law firm can do to help you get the maximum um, out of your potential case. This particular consult, I've done it hundreds of times. So instead of having you come to the free consult and just listen to the same thing I've told hundreds of people, I decided to go ahead and commit this to an audio video recording, and that way you're able to listen to it, and then when you come to the consult, you can actually ask poignant questions to your case, and we can have a dialogue. That'll be better, I think, for in terms of giving you guidance as opposed to me going through the basics, which I had to do in nearly every consult prior to this video. So identity theft typically takes one of three forms. Number one, somebody uses your PIDs to get access to your electronic checking or savings or other liquid accounts and takes money out of your liquid account. Those transactions are typically covered by a federal statute called the Electronic Funds Transfers Act. And this particular federal statute has a number of requirements that are going to impose themselves on a consumer, like putting an institution on notice within a certain time period, telling the bank that, hey, there's been a theft of my funds, and then the bank has either 10 days to investigate, put the money back, or to give you a provisional credit and investigate for 45 days, and then make a final determination as to the funds. The federal regulation is extremely complex, and it's too much to get into in a short video. But suffice it to say, I just wanted to give you an introduction to EFTA and tell you that we will be sending you an EFTA questionnaire and follow-up email and give you some knowledge and information about what it is that the statute does, and that you may be able to have a claim against your banking institution to get your whatever monies were taken out of your account without your consent and permission back. The statute also has an attorney's fees provision and a treble damages provision where if the bank violates certain portions of the statute, you may be able to get back as much as 3 times the amount that was taken from you. The one not so much as a drawback, but consideration with EFTA is you have to bring the claim within 1 year of when it accrued, meaning typically that means within 1 year of when the monies were taken. There's very narrow exceptions to that. So time is of the essence. If you have an EFTA claim, you need to get with an attorney right away. Some claims won't be covered by EFTA because EFTA has certain provisions that could create an exclusion. If an exclusion is created, you may have a UCC or a breach of contract claim. We don't handle those claims, but I can refer you to an attorney that can handle that aspect of the claim if in fact EFTA isn't productive for you. At this point, we don't handle those claims, but we may in the future, and if we do, we'll put you on notice at the consult that we can represent you on that. The second type of interface that a consumer can have with identity theft is when the consumer gets a debt collections letter, or they get sued for a debt, and it turns out the debt was brought about by an identity thief using your PIDs to apply to a financial institution while they're pretending they were you, and then setting up the account. If such a event happens, right, like you first get when, hey, I'm a victim of identity theft. There's somebody using my PIDs to commit financial transactions. The first order of business is to find out how pervasive is the identity theft, right? That means where is the identity theft happening? How many different types of variation of theft has happened using your PIDs? And kind of like the Bible, okay, of identity theft and inquiry is the list of consumer reporting companies from the CFPB. I actually have that on my screen, so I'm going to go over that with you. So most people think about credit reporting bureaus as the big three, right? Like the big three include Equifax, Experian, and TransUnion, right? Those are typically called the nationwide consumer reporting companies. It says Equifax, Experian, and TransUnion. By the way, for you to come to your appointment and have a productive appointment with me, you need to have at least your big three reports. You need to get your reports from a website, which I can highlight right here for you. It's called the annualcreditreport.com. Okay, this is an FTC website that is set up by the federal government. You can log into the website and you can download your consumer report from the website directly and then review the report to see if there's any evidence that either an address, a phone number, a trade line, like a auto loan or a credit card or anything like that similar to that is on the report that you don't recognize as having been a part of your consumer history, right? So if at the very minimum, try to get these three reports when we come to the appointment, we have an idea, hey, this is what's happened. Try, if all possible, not to engage in any monitoring service with the Bureau that may result in you having to agree to arbitration. And that I think is a big problem, right? Like a bureau says, oh, the person has identity theft. We'll give you a monitoring service. Of course, the monitoring service fine print says if you ever have a claim against us under, for example, the Fair Credit Reporting Act, that claim has to go to arbitration. So you lose your Seventh Amendment right to a jury trial, which is, in my opinion, an extremely big uh, cost, and it's to be avoided at all costs. So you don't have to go to their website or agree to a monitoring service. The federal government has an agreement where they have to provide you with a report using the annualcreditreport.com. If you are not able to get your report through the annualcreditreport.com, we will send you a instruction packet where you could send them a mail-in request to get the report, or an alternative, you can call, identify yourself using the phone questionnaire, and they will mail you the report to your home when you get it. You can scan the report and either upload it to your portal or provide it to us through the inquiry system, the follow-up email system that the firm automatically will follow up until you provide your report, and we know you have it. The firm will continuously follow up. But what I wanted to talk to you at the consult was it's not just so much that these big three, Equifax, TransUnion, Experian, it's not so much that, of course, you have to get those reports. Like those are kind of like the basic three building blocks, right? How extensive is identity theft? Well, do you have your big three reports? However, the reports that I'm more interested, excuse me, as interested as getting you to provide for us have to do with these other areas of inquiry. For example, there are employment screening companies. If somebody has, there are tenant screening companies for when somebody is using your PIDs to rent an apartment and you have no idea that this is happening, right? Until you get served with an eviction notice, right? And you realize for the first time, oh my God, somebody is renting an apartment pretending they're me. That is incredibly common. Because people with bad credit, they go rent an apartment and they realize they can't get approved, so they'll just use somebody's PIDs who has good credit. They'll live there for months and pay the rent, and nobody has any idea until there's a collections effort being reported on the credit report or on one of the tenant screening reports because they left and didn't clean the place up, or they skipped out on the rent after staying there for so many months. There's also check and banking account screening reports, and I'll go down a little bit further in the packet and I'll show you how to get those reports. That has to do if you're a victim of identity theft, sometimes what the identity thief will do is they'll set up like an account, a mule account, to pretend, because they can't just steal the money and put it in their own account, right? Then it would be discovered, hey, you stole the money. So they'll use a pretend account, pretending there's somebody else, so they can transfer the money several times so they can get their hands on it. So that this particular checking and bank screening reports help you determine if there's any irregular identity theft related activity on your reports stemming from your checking and savings accounts. Personal property insurance is a good one. It's not huge. There's a supplemental reporting company called LexisNexis Risk Solutions. I always recommend that the LNRS report is also obtained. That particular bureau report may contain inaccurate information. The medical, low-income, subprime, and retail and gaming, I haven't had too much experience with those, but I know that the utilities uh, one and the supplementary reports are huge. Utilities one especially because the utilities report has a company called NCTUE, and if an identity thief uses your PIDs to get a cell phone and then uses that cell phone to start a credit card account or a bank account and uses that cell phone to two-factor authenticate the account, you'll have absolutely no idea what is going on for a while. And even when you go to try to correct that problem, it may not work because the cell phone is floating out there in their possession with your PIDs. So the utility report is a great way to find out if, in fact, there is that level of identity theft going on. So I think the most important piece of information I can depart is the the CFPB has agreements, with these bureau providers to help you get your report without having to sign any kind of agreement to go to arbitration. And just before I move on, too, there is a segment of the population who are attempting to to get a job. And when they do the job application, the applicant comes back and says, "Well, you have a felony." And the person's like, "No, I don't." And the Fair Credit Reporting Act regulates inaccurate information regarding criminal history that may be on your application that belongs to somebody else, right? So you can pull your employment screening reports if you're attempting to apply for a job and you've been denied because you were told that you had a dirty consumer report when in fact you didn't, because there was a mix, like there was same name or similar date of birth was one date off and they just didn't do an accurate enough check. So I just want to show the employment screening. There's quite a few employment screening reports. There's accurate, ADP, assurant, background checks, Blend Insight, CCC Verify. It goes on for quite a bit. If you have an employment denial case based on mixed information or mixed file, you need to pull as many of these reports as you can possibly get to figure out which one provided the information, the inaccurate information to your prospective employer. The tenant screening reports are also here, and the packet is very helpful. And once you come to your consult, we will, once we qualify you, we will send you the portion of the packet that's more relevant to you, and then you can go to the packet, and it has a website, a phone number, and you'll be able to order your report. These are the reports for the tenant screening reports. There's quite a few there, and then after that, you'll see checking and savings accounts. They're all right here, and again, there are 1-800 numbers, guidance for how to request a form, and you can even go to, like, for example, with Certegy, check systems, CrossCheck, EWS, and GPC, Global Payment Services. Um, has a website as well, an 800 number with an extension that you can call. You can also write them with a letter and identification information to get your consumer reports. It's just so important to make sure that however you get your reports, that you read through the interface and make sure that there isn't any agreement that you go to arbitration, because they're required to give you the report under the law. Right? Section 1681G of the Fair Credit Reporting Act makes it mandatory that if a consumer asks for a copy of their report, that they have to give you the report. So that's not negotiable. So you don't have to agree to arbitration to get a copy of your report. But sometimes there'll be a build-in, right? It's like, well, we'll give you free monitoring and we'll give you, like, this and that. You just sign right here and we'll give you a report too. But absolutely avoid that if at all possible. It is a big trap. You don't want to inadvertently waive your right to having a Seventh Amendment jury trial that's guaranteed by the U.S. Constitution, unless you waive it. If you waive it, then that's a problem. But if you don't waive it, um, you never want to give that right up, because that'll be very, very important later. But the most significant consideration is that, and this is another really important, so the supplemental report, LexisNexis report, lexisrisk.lexisnexis.com, and they also have a phone number for LNRS, LexisNexis Risk Solution, to get your consumer report. And so what's important is to First, understand you need to do an inquiry on your own. You need to get your reports to us so that we can investigate and determine how extensive the identity theft is. That's step one. And that's a very important critical step. And a lot of people fall through the cracks in that step because they don't show diligence to get their reports. Now, we have technology in place that's going to follow up with you periodically once I prescribe which reports to get. And it's your job to make sure that you get us those reports. If too much time goes by and you're not showing an interest and cooperating with the firm infrastructure and getting us your reports, and or you're not calling me and saying, hey, I'm having a hard time getting this report. I've asked for it many times. They won't give it to me, or they sent me a letter telling me to further identify myself. I already sent them my ID. Unless there's a snag and you provide it to us, if so much time goes by and you don't respond to us with the reports, we assume you've lost interest. And this area of practice is not like personal injury where there's like 10 lawyers in one car accident. This is the opposite. This is like there's 10 identity theft victims in one lawyer. It is federal practice. It's incredibly complex. It's driven by deadly deadlines. You have to be able to write and think and practice at the highest level in the country. I mean, federal court practice is not on the same plane as state court practice in most instances. Okay, it isn't. So the number of practitioners in this particular field are small, to say the least, very small. You can find hundreds of lawyers that do personal injury. Fair Credit Reporting Act litigation in federal court with deadly deadlines in the Southern District of Florida or the Middle District of Florida, which is a very busy district where the courts are handling a massive ton of cases where the deadlines are not necessarily negotiable. Now that's an entirely different problem. Okay, so if we start to get resistance from the client's not returning calls, not responding to email, not getting us their reports, we drop them. We just send them a letter and say, hey, we're very sorry. We just can't help you. You're not a good match for our firm, and we'll move on. I mean, we get a lot of inquiries, and that's why we have to set up systems to keep track of. So please, I just want to really emphasize, you need to be serious and disciplined about getting us those reports. We can't get the reports for you. Like that's impossible. We can't like, first of all, we wouldn't do that anyway because that's kind of a red flag. It's like, hey, if you don't want to get your own reports, or why should I have to bring staff in to invest dozens of hours to get the reports? You need to be responsible to get your own reports to see where the identity theft is. If you're not interested in doing that, that to us is a red flag that, hey, this is not going to be a really good marriage for us, and this is probably not the best client for us to get lined up with and to try to get them relief. But if you can get us the reports, then that's the first step. Second step is, okay, we read the report with you. We determine where the misinformation, whether it's identity theft or even if it's an inaccuracy or some other form of incomplete, unverifiable, inaccurate information, not necessarily stemming from identity theft, but from some mixed file or a bill that you paid, you have a proof of payment, and the creditor says you didn't pay and it's more on your credit, whatever the case may be. We will write a dispute letter for you. Okay. Sometimes we will do multiple disputes for reasons that I'll discuss with you more during your confidential consult. But at the very minimum, we'll do that one dispute letter and we will mail it off for you using our tracking systems so that we can prove that the dispute was sent in court later. If the Bureau does not fix the information, meaning remove the inaccuracy, whether it's due to identity theft or whatever the case may be, then we will file a lawsuit in the appropriate federal court against the Bureau and allege that they violated the Fair Credit Reporting Act. Our fee agreement works on 100% contingency, which means that we don't recover monies from your lawsuit. You don't owe us anything. I will describe the details of the fee agreement later during your confidential consultation, but the fee is a 100% contingent. Under the Act, we are the at-fault party is required to pay for your attorney's fees. And I said this in the prior outbound video. The first video is, if you're a victim of identity theft, and you're a normal person that has a job, a responsibility, families, limited time in a day. If you got to go hire a lawyer for $400 or $500 an hour, how's that statute even functional? Like, Congress has the wisdom to know, hey, if a bureau or a furnisher breaks the law and they report information that was related to identity theft or is otherwise inaccurate, and they break the law after the consumer puts them on notice, they are required to pay for the consumer's attorney's fees. That's generally the extent of the identity theft inaccuracy. There are two other statutes that have to do with debt collections efforts. If you receive a debt collections attempt, whether it's you get served in a lawsuit or somebody pretending to be a debt collector or somebody who's a debt collector that is attempting to collect a debt that was brought about by somebody pretending to be you, calls and harasses you at different hours and whatnot, you can file a counterclaim against them using the Fair Credit Report, using the Fair Debt Collection Practices Act, or Florida has a corollary, which is the Florida Consumer Collection Practices Act. Now, keep in mind, these statutes, they all have 1 and 2 year limitations period. FICRA has a 2 year limitations period, although for 1681I claims, it can be reset if you send a subsequent letter. But the FDCPA and the FCCPA have a 1 and 2 year limitations period, respectively. So if you get sued in a unlawful debt collections attempt, you need to don't walk, you need to run and retain counsel immediately, because once that judgment is recorded, it becomes exponentially more difficult to fix. But if you retain an attorney right away after service, yeah, we can file an appearance, or even just a debt collections defense firm can typically file an appearance and challenge the debt and say, hey, this is identity theft debt, this is not the client, and move to defend the claim and even get their attorney's fees, and you may even be entitled to damages. Under the Fair Credit Reporting Act, you're entitled to punitive damages for willful conduct on the part of the defendant, actual damages for emotional distress and loss of quiet enjoyment of life, inconvenience, any actual monetary damages, plus statutory damages, plus attorney's fees. So you do have a menu of potential relief that you could attempt to have us explore for you once we're in court. So that's generally the flavor of identity theft. I always get this kind of, I kind of feel like I have to emphasize this too. Look, if somebody is walking around pretending they're you buying stuff, right, that doesn't really hurt you until you either become the victim of collections attempts, or it ends up on your credit report, or it hurts your reputation, right, by ending up on your credit report, meaning you can't conduct business as usual. But the Fair Credit Reporting Act is a phenomenal vehicle. I mean, Congress it just did a really great job with this statute, because if you have reporting on your consumer report, you not only get to sue the bureau, but you sue the information furnisher. Like, for example, a phony Capital One card, or whichever one. I don't just say Capital One because that's the one that came to mind. But if you have a phony credit card by a bank that was procured by identity thieves, it has reporting on your consumer report, say with Experian or Equifax or whichever one, and you file a lawsuit, it's not just against the bureau, it's also against the bank. And they have to come, so, once you, and hopefully either win your case in court or resolve it through some other mechanism, you would ask the defendants to wipe the trade line clean, wipe the debt clean, take it off your credit reports, and also pay the damages. So it really is a phenomenal opportunity. The problem with the act is twofold. One, consumers aren't disciplined with getting the reports to counsel and following through with communication, and don't stay on top of their case. And with the volume of inbound cases that we have to deal with, I mean, we're very picky, because and I also know, like, once we get into a federal law, we have to have a cooperating client that's like cogent and productive and like listens and can return calls and that sort of thing. So that's the first problem. The second problem is there just aren't very many practitioners that have the skill set. I mean, it takes a good 5 to 7 years to get the basics down, because the statute, I mean, it's immensely, it is staggeringly complex. I mean, if you read it, it's not that complex, but once you go to apply it, the amount of research and writing you have to be able to do it in federal court with the deadlines, and then to even be able to get geared up to trial, to even be able to gear up to try a federal case. It's mind numbing. So the client has to be organized, they have to cooperate with the firm, and the lawyer has to know this practice area. One final word of warning word: if you have spoken to an attorney and the lawyer says, "Yeah, I can maybe help you out with this, but it's going to require a retainer of $2,000 or $3,000 or whatever the case is for this type of case," run the other way. There is no reason why any lawyer should ask you for any kind of a retainer. Now, a little bit of etiquette for your consult. Look, the consults are complimentary. You get 30 minutes to come to the consult and speak to the attorney. And they have to be done by Zoom, especially if it's identity theft, because we take a screenshot of you and the attorney that does the consult, and we'll save that in the client's uh, confidential folder on our systems. So we have to be able to identify you, make sure nobody's pretending to be you. I mean, that you never know. So we have to be careful about that. And we do take screenshots with the permission of the client. We'll say, hey, say hi, and we'll take your shot. Now, when you come to your client, to your consult, you need to be prepared. You need to make sure your Zoom link is functional. You need to know how to use Zoom so you can appear to technology. We do have some systems where we can prompt you to like start your camera, but you need to make sure your audio is working and at least like maybe do a test run with the Zoom to make sure your cell phone or your laptop or whatever the device is has the appropriate software, that the software has access to the microphone so that you don't have technology blink. And most important to me, when you come in to do your attorney consult, please, this is a complimentary consultation. There are hundreds of people that are calling the firm trying to get appointments. So if you navigate yourself through, if you get an invitation and you fill out the questionnaire and you get a consult and you get your free 30 minutes, make sure you're in a quiet place. If you show up in your consultation and you're like walking around the shopping mall or driving, we immediately terminate the consultation. We can't do consults like that. You do need to make sure that when you come to the consult that you listen to the video, that you're ready, and that you're able to pay attention and to understand and appreciate the not only be able to ask questions, but to be able to understand and appreciate the answers you get. Once you come to the consult, one of two things will happen. Either we feel like your your case has an actual immediate need for us to get retained, and we'll send you a retention agreement by our Adobe platform, or we'll put you in a holding pattern and say, hey, go get us some reports. We want to see a little bit more about what's going on with your case. And then if you get back to us with the reports, then we'll send you a retainer. The only follow-up comment is like of the clients that we retain, either because they had an immediate issue and then we dropped them, or we put them in a holding pattern and they didn't comply with the report gathering requirement, the chances of being rematriculated into the firm are less than 10%. We just have too much volume. And I really want to emphasize that during the video because, listen, we would love to help you. We want to work hard for you. We want to get an outstanding result for you. We want to fix your problem, but there aren't very many lawyers that do this type of work. It's taken us, me especially, over 10 years to learn how to navigate this particular space. And fortunately, we're in a position where we can choose who we want to help, and you really have to want the help. So if you have to be prepared. You have to be in a place where your machine is working, you're in a quiet place where you can do the consult. You have to get us to reports. If you're unable to do that, we'll just assume it's not the right time for you and us to be on the same team, and we'll just close your file. And then because the inbound volume of subsequent cases is nonstop, there's an incredibly small chance. I think so. That's just very rare. So please cooperate with us. Come to your appointment prepared. Let us help you get an outstanding result. I know identity theft isn't nobody looks forward to identity theft. I know that, but if you do have genuine identity theft, we can help you. We can get you an outstandingly good result. We will do everything possible to get that accomplished for you, and we look forward to speaking to you soon. Thank you.